Maybe
Yes.
one matter is unusual. Tomorrow, maybe the state, the worship had rejected my.
Tomorrow.
Yes, tomorrow. It was 5 years study.
Okay.
Obliged.
May I please, Your Lordship? Lordship, I'd like to mention for listing of it to anticipatory bail application, Lordship.
When?
For tomorrow, Lordship.
Tomorrow.
Because, Lordship, the brother of the petitioner was arrested, Lordship, and his mother also, old aged mother, Lordship. He is now and subject to correction.
It's first application or second
First
application?
application, Lordship.
Okay.
But-
Okay.
Lordship. Deeply obliged.
Item number 3, my lord.
Pardon?
Maybe item number 3, my lord. Maybe
Ah.
taken, my lord, except today, my lord. Any other day, my lord, except today.
On the pair being made by Mr. S.
Any
Raman,
other
Learned
thing?
Counsel for the accused, SSL is the matter on. Okay.
On 7th June.
Obliged, my lord. Most.
For admission, item number 1, started matter.
Please, Your Lordship.
Yes.
I was supposed to file an affidavit today. The affidavit is ready, but some pages are to be typed. Today, Lordship may kindly give me 3 days time, Lordship. It will be filed by Tuesday at any cost, Lordship.
On the pair being made by Mr. A. Bhattacharya, Learned Counsel for the petitioner. SSL is the matter on
On
4th,
4th,
Lordship, 4th.
court.
Deeply obliged.
Till then interim order for service shall continue.
Item 2, related. Item 2, item 2.
That is a 376 matter, 306 matter.
Yes. So on the other day, what was the issue?
My lord was asking whether revision is maintainable or not. I had supplied one judgment of the Honorable High Court of this High Court, where a revision application was dismissed on merits. Subsequently, Supreme Court entertained it and allowed.
Hmm.
That is one aspect. Secondly, I had given a judgment of 1977, a 3-bench Court of Supreme Court,
Hmm.
3-bench Judge of Supreme Court, 1977, 4 SCC 551.
Yes, Modulimai. Modulimai case.
Modulimai. Yeah,
Yes.
in this judgment, what has happened? Charges were framed under 500 CRP, IPC.
Hmm.
It was challenged in revision petition.
Hmm.
High Court had dismissed, saying that there was no revision petition was not maintainable. But Supreme Court said the revision petition under against charge is maintainable, and the matter was relegated back to the High Court to be decided on merits. So, Lordship comes to paragraph 13 and 18 of that judgment. 13.
No, on the other day, you have argued on this point.
My lord.
Thereafter, I put another question that
My
was,
lord.
can this court appreciate the evidence?
Yes, my lord.
That
For-
was the question.
Yeah, for that, I had given earlier only. I have given a judgment of 2010, 12 SCC,
2010,
12 SCC 190.
Yes.
My lord, this is a case of 306. This also is a case of discharge. Here, court has taken the view, my lord. If
So
your lordship,
what is the ratio?
my lord takes up page, sorry, paragraph 24. At page 197, paragraph 24.
24 is the quote from another judgment.
My lord,
What is the
my
view
lord will
of
come.
that
My lord will come to 25 then.
Hmm.
Abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a thing.
Hmm.
Without a positive act on the part of the accused to instigate or aid in committing of suicide, conviction cannot be sustained.
Hmm.
Intention of the legislature and the ratio of the cases decided by this court is clear that in order to convict a person under 306 IPC, there has to be clear mens rea to commit the offense.
Hmm.
It also requires an active act or direct act which led to the deceased to commit suicide, seeing no option that the act must have been intended to push the deceased into such a position
Hmm.
that he committed suicide.
Hmm.
Paragraph 27 says, when we carefully scrutinize and critically examine the facts of this case in the light of the settled legal position, the
Hmm.
conclusion becomes obvious that no conviction can be legally sustained without any credible evidence or material on record against the appellant. The order of charge under 306 against the appellant is palpably erroneous and unsustainable.
Hmm.
It would be travesty of justice to compel the appellant to face criminal trial without any credible material whatsoever.
Hmm.
Subsequently, it was squashed.
No, that's all right. Supreme Court has dealt with the same in appeal.
No, but
That
this
was
is
in
a
appeal.
this is a discharge case.
No,
Supreme-
that's all right. Supreme Court has dealt with the issue in appeal.
Well, Supreme Court, everything that once one SLP is admitted,
Hmm.
it is numbered as a criminal appeal.
No, yes.
Once SLP is admitted,
Hmm.
then my lord, I have given another judgment. It's a small order, my lord, 2-page order.
Hmm.
My lord, it was passed by 2-page order, Justice Nageshwar Rao and Aniruddha Bose. So,
Yes.
Small order, my lord.
Hmm.
If your lordship, there's no paragraph number in that. If your lordship comes to the second page of that, after investigation, charge sheet was filed against respondent 2 and 4. Trial commenced against respondent number 2 and 4. Respondent so and so preferred criminal revision before High Court of Madhya Pradesh at Indore. The High Court allowed the revision filed by the respondent number 2, agreed to which petitioner preferred. They had come against charge.
Hmm.
If your lordship says this is also a criminal appeal, once SLP is admitted, everything becomes a criminal appeal.
Hmm.
In this same case, my lord, if your lordship comes to that same page, paragraph 2 from bottom, in order to bring a case within the provision of section 306 IPC, there must be a case of suicide. And in the commission of the said offense, the person who is said to have abetted the commission of suicide must have played an active role by an act of instigating or by doing a certain act to facilitate the commission of offense, suicide. Mere harassment without any positive action on the part of the accused proximate to the time of occurrence which led to the suicide would not amount to an offense under 306 IPC.
Hmm.
Abetment of a person is when a person instigates another to do something. Instigation can be inferred where the accused had by his acts or omission created such circumstance that the deceased was left with no other option except to commit suicide. In the instant case, allegations against respondent number 2 and 4 is that they harassed the deceased. There is no material on record which indicates abetment. The High Court did not commit in any error in allowing criminal revision.
Hmm. No, still my question remain unanswered.
Your lordship is saying this has been held up in appeal.
No,
Supreme
no,
Court-
that's all right. The proposition of law laid down in this cases, there is no dispute, no further.
My lord,
My question is, can sitting in revision, High Court can appreciate the evidence?
yes, my
That
lord.
is the question.
I had given one more judgment in that. My lord,
Yes.
2022 SCC 768.
Hmm. Relevant paragraph?
My lord, paragraph 17. There are certain principles laid down.
Hmm.
Paragraph 17. We'll go from 17.1.
Hmm.
If two views are possible and one of them gives rise to suspicion only, as distinguished from grave suspicion, trial judge would be empowered to discharge the accused.
Hmm.
The trial judge is not a mere post office to frame the charge at the instance of the prosecution.
Hmm.
The judge has merely to sift the evidence in order to find out whether or not there is sufficient ground for proceeding.
Hmm.
Evidence would consist of the statements recorded by the police or the documents produced before the court. These are the 207 papers.
Hmm.
17.4. If the evidence which the public prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. 17.5. It is open to the accused to explain away the materials giving rise to grave suspicion. 17.6. The court has to consider the broad probabilities, the total effect of the evidence and the documents produced before the court, any basic infirmities appearing in the case, and so on. This, however, would not entitle the court to make a roving inquiry into the pros and cons. 17.7. At the time of framing of charge, probative value of the material record cannot be gone into, and the material brought on record by the prosecution has to be accepted as true. 17.8. There must exist some materials for entertaining strong suspicion which can form the basis for drawing up a charge and refusing to discharge the accused. And 18 also says, 18 says, what is the meaning of record of the case? Whatever has been collected during investigation has supplied to the accused under 207 CRPC. That is the record of the case. In fact, in this citation, what has happened? The accused wanted to rely on a document as defense evidence. Court said at the time of framing charge, you cannot rely on your documents. That will come at the stage of trial. But materials on record, do they show an offense? And in the case of 306, where 107 is the main offense, abetment, where is the positive intent on my part? In fact, my lord, the judgment that I gave of our High Court, which was rejected on grounds of merit, on meritorious grounds, it was when we went to Supreme Court, 302 was set aside the charge against 302 because no mens rea was found, no motive was found. Your lordship is well endowed with the power under 397-401 because 397 says any order, if illegal. 397 is the power of the session court also.
Mm.
It's a concurrent power of session court and high court. 401 is the power where high court calls for the records of the lower judiciary.
Mm.
Your lordship is well endowed with the power. In fact, the small Supreme Court judgment that I gave 3-page, the first paragraph says that revision was filed in the High Court of Indore, Madhya Pradesh at Indore, and it was allowed. That was under 397-401. It specifically mentions that.
Mm.
And that same judgment says mere allegation that harassment has been inflicted upon the person does not amount to 306.
Mm.
In fact, the Supreme Court judgment where abatement is defined, paragraph 25, in that same judgment of 2010, paragraph 22,
Mm.
suicide note was given. That I am committing suicide because of this reason, my husband was having an affair with somebody. Even that does not amount to abatement. That is what the Supreme Court has said. In my case, my lord, father says we doubt that she has died because of the accused. He has given the phone numbers that she was talking to this. On the time of just before that time, only allegation is, imputation is she was talking over the phone and crying. To whom she was talking, there is nothing. Mother makes out a story that there were things becoming viral amongst of us. Nobody says that there were videos or photos viral. Nobody. Only mother says that. Under such circumstances, where is the instigation on my part? Where is the positive act on my part to make her to take that final decision? There has to be a positive act on my part.
Yes. Okay, Mr. Devi.
May I respectfully submit, your lordship, 306, your lordship may kindly peruse for a moment. Abatement to suicide.
Mm.
It says, your lordship, if any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. The first thing is, your lordship, instigate any person to do that thing. This is a main ingredient, your lordship. Now, accept the fact that this particular accused was talking to the girl, your lordship. There was no other incident. So that means an inference can be drawn that he was the one who has been instigating the girl to do the act. So prima facie at this stage, your lordship, in my respectful submission, he may be the charge is already framed, your lordship, he may face the trial. That's my respectful submission. And your lordship, there is a judgment of the Honorable Supreme Court today. 2012 9866640. Just relying on one paragraph, your lordship. Paragraph 19.
Para number?
Paragraph 19, your lordship. May I read, your lordship?
Yes.
At the initial stage of framing of charge, the court is concerned not with the proof, but with a strong suspicion that the accused has committed an offense, which, if put to trial, could prove him guilty. All that the court has to see if that material on record and the facts could be compatible with the innocence of the accused or not. The final test of guilt is to be applied at that stage. We may refer to the well-settled law laid down by this court in State of Bihar versus Ramesh Singh. Under section 226 of the code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused. Thereafter comes at the initial stage the duty of the court to consider a record of the case and the documents submitted therein and to hear the submission of the accused and the prosecution in their behalf. The judge has to pass thereafter an order either under section 227 or section 228 of the code. If the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing as enjoined by section 227. If on the other hand, the judge is of the opinion that there is no ground for presuming that the accused has committed an offense which is explicitly trialed by the court, he shall frame in writing a charge against the accused as provided in section 228. Reading the two provisions together in justification as they have got to be, it would be clear that the beginning and the initial stage of the trial, the truth, veracity, and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged. Nor is any weight to be attached to the probable defense of the accused. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. The standard of test and the judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under Section 227 or Section 228 of the Code. At this stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. But the initial stage, if there is a strong suspicion which leads the court to think that there is a ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. The presumption of guilt of the accused, which is to be drawn at the initial stage, is not in a sense of law governing the trial of the criminal cases in France, but the accused is presumed to be guilty unless the contrary is proved. But it is also the purpose of deciding prima facie whether the court should proceed with the trial or not. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. An exhaustive list of the circumstances to indicate as to what will lead to one conclusion or the other is neither possible nor advisable. We may just illustrate the difference of the law by one example. If the scale of pens as to guilt of an accused of the accused are something like even at the conclusion of the trial, then on the theory of benefit of doubt, the case is to end in its acquittal. But if on the other hand, it is so at the initial stage of making an order under Section 227 or 228, then in such a situation, ordinary and generally the order which will have to be made will be one under Section 228 and not under Section 227. So it makes it very clear, Your Lordship. At the initial stage, Your Lordship, in my respectful submission, the charge has been rightfully framed, Your Lordship.
So, have you gone through the judgment the counsel for the petitioner has relied upon? On the other day, perhaps a list was given to you.
No, Your
I had,
Lordship.
I gave the citations. 2020.
Kuntu? This is rate. I'm sorry, Your Lordship. It will be SSC, you know, Sina. Your Lordship, with respect to 2010-12 SCC 190, although the court has clearly stated in the last paragraph, Your Lordship, that 25, paragraph number 25, abatement involves a mental process of instigating a person or intentionally aiding a person in doing a thing. Without positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. Now, my respectful submission, Your Honor, Your Lordship, in this case is that
Is there any positive act on the part of the petitioner?
positive fact, Your Lordship, is that all the witnesses had clearly stated that the girl was talking to the accused person prior to her committing that particular act. That part as on date has been there, Your Lordship. So it is very clear that there has to be some investigation. And he needs to explain why she committed suicide. She committed suicide because the allegations, Your Lordship, may kindly see, they have very categorically stated, the father, the mother, and the brother, that she was talking to the accused person. and thereafter she has committed suicide. There is no other act. The prosecution is very clear on that point, Your Lordship. So my respectful submission, Your Lordship, is that there has to be some investigation. And it is at this stage, Your Lordship, without the cross-examination of the witnesses, without examining the witnesses, it is very difficult to establish the fact that the accused person has not instigated the victim to commit that particular act, Your Lordship. So in my respectful submission, Your Lordship, although the Supreme Court has stated in this case that without positive act on the part of the accused, but in my respectful submission, Your Lordship, in this case, there is an act on the part of the accused, and all the three witnesses have very specifically and categorically stated that the girl was talking to the
As per his instruction, the officer ensures jurisdictional PS has received the notice, and the report of service of notice is to be obtained by Monday, and press for listing the matter on Monday. Prayer is accordingly allowed. Mr. S. Islam, learned counsel for the applicant, present.
Monday, my lord.
Monday.
Item number 7,
CD was called for.
Yes, Sharma, you
My CD receive my lord, 7, 8, 9. All of that same, my lord. 7, 8, 9.
yes,
Same CD, my lord.
yes. No,
Wait.
yeah, one by one.
My lord, my lord.
It is item number 7.
7, my lord.
Pursuant to.
He appeared before the IO.
Appeared before the IO.
Statement is recorded.
Statement recorded.
So what is the stage of investigation?
My lord, investigation is going on, my lord. Before my lord, passing the order, lordship may kindly place 2, 3 witnesses, my lord. I was collected, my lord, sufficient material evidence, my lord. From the CCTV also it was recorded. Several eyewitnesses there, my lord.
That is their eyewitnesses. But if he has been cooperating with the investigation, then
And that is different, but IO has collected materials, my lord, against him. All of them involved in the case.
heard Mr. Is thus learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Entered is number 2 and number 3. Mr. Das, learned counsel for the applicant, submits that the applicant was granted the privilege of peerless bail by order dated 29/4/2024, and pursuant to that order, he had appeared before the IO, and his statement is also recorded, and he has been extending cooperation with the investigating agency. And therefore, Mr. Das has contended that the interim order dated 29/4/2024 may be made absolute in the same terms and conditions. Whereas Mr. B. Sharma, learned additional PP, has produced the case ID before this court and submits that the IO has collected incriminating materials against the present applicant. However, Mr. Sharma submits that he had appeared before the IO and extending cooperation with the investigating agency. Thereafter, is having heard. Next paragraph. It is not in dispute that the applicant had appeared before the IO and cooperating with the investigating agency pursuant to order of this court dated 29/4/2024. Though the IO has collected some incriminating materials against the present applicant, and based on which Mr. Sharma has opposed the pair. Yet, in view of the cooperation being extended by the applicant, as well as the progress of investigation, further custodial detention, interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 29/4/2024 absolute in the same terms and conditions.
Obliged.
Will be returned.
8.
May I please, Your Lordship? On similar footing, Lordship, interim was granted and I appeared before the IO and the statement was recorded.
my lord, same submission, my lord, all of them together, my lord. My objection is there.
Same order. 7, 8, 9.
Okay, much obliged, much obliged.
And
Yeah, please, proceed. Same case, there's an interim.
My lord.
You are on interest?
Yes, interim, my lord.
for hearing, item
Okay.
10. Item number 10.
Yes, so both the parties are ready to argue the matter.
Today I'm not properly ready also.
Pardon?
I am not ready today. Some other partner matters are there also. চোৱাও আছে আজি চাব পাৰোঁ ৰাতিপুৱা
Is this Surya learned amicus curiae is present? Mr. P.S. Locker, learned additional paper present and submits that he is not ready to argue the matter today. Accordingly, it is provided that receives shall list the matter on suggested date.
On 12 June, 12. Item number 11.
Obliged, Lordship.
item number 14 14 item number 5 item number 5 was he appeared on my telephonic instruction
11.
Okay, we will pass the order. We will make the interim order absolute.
Deeply obliged.
Yes, so what was the issue on the other day?
Now, you have to express on about remove Maruti Kikan. What I have to say
Pardon?
about the husband, Maruti
Yes.
Kikan.
On which point?
About no eyes there, no eye witness. There's no eyewitness.
Yes. So the
And even if-
accused and the victim were in the same room.
No, he was not present as per the one step.
No, may not be.
But
That is your plea. But what that judgment states,
this is just my submission.
in the case based on circumstantial evidence, when no eyewitness account is available, there is another principle of law. That is, when an incriminating substance is put to the accused, and the accused either offers no explanation or offers explanation which is found to be untrue, then the same becomes the additional link in the chain of circumstances to make it complete. However, in the present case, the accused Suman Sharma had specifically stated to the answer with respect to question number 49 of this 313 CRBC statement, wherein the accused has stated that accused that is his wife was ailing from a long time and she was also treated by her parents. Moreover, the accused has stated that he had medical documents of her treatment. The principle laid down in Ina Hajoga case, the accused established his defense or innocence beyond all reasonable doubt. The accused needs to only raise doubts on the preponderance of probability. In the present case, the wife of the accused had expired due to hemorrhage inside the abdomen cavity as a result of splenic injury. As per the postmortem report, there is no external wound present. The prosecution has failed to establish the defense that the accused is responsible for causing any injury to the abdomen of his wife. Thus, the explanation offered by the accused is reasonable. Absence of an eyewitness in the present case cannot be used as an additional link in the chain of circumstances to make it complete.
No, perhaps on the other day, we have discussed about this principle laid down in Trimukh Maruti Kirtan.
Yes, sir. This is the principle. This was the.
So are you reading this from that judgment?
Yes, yes, yes.
Which paragraph?
Back up 7. 17. Paragraph number 17.
In SCC online laws, paragraph 22.
Paragraph?
In SCC online, paragraph 22.
Yes.
When an accused is alleged to have committed the murder of his wife and the prosecution succeeds in leading evidence to show that shortly before the commission of
Wait. See that one.
Yes.
commission of crime, they were seen together, or the offense takes place in the dwelling home where the husband also normally resides. Here in same footage also. It has been consistently held that if the accused does not offer any explanation how the victim receives injuries or offers an explanation which is found to be false, it is a strong circumstances which indicates that he is responsible for commission of the crime. In Nikaram versus State of HP, it was observed that commission of the crime in that the fact that the accused alone was with his wife in the house when she was murdered with kukri, and the fact that the relation of the accused with her were strained would absent in the absence of any cogent explanation by him point to his guilt. In Ganesh Lal versus State of Maharashtra, the appellant was prosecuted for the murder of his wife, which took place inside of his house. It was observed that when the death had occurred in his custody, the appellant is under an obligation to give plausible explanation for the cause of her death. In his statement under section 313 CRPC, the mere denial of the prosecution case coupled with absence of any explanation was held to be inconsistent with the innocence of the accused, but consistent with the hypothesis that the appellant is a prime accused in the commission of murder of his wife. In State of UP versus Dr. Ravindra Prakash Mittal, the medical evidence disclosed that the wife died on strangulation during late night hours or early morning, and her body was set on fire after sprinkling kerosene. The defense of the husband was that the wife had committed suicide by burning herself and that she was not at home at that time. He was not at home at that time. The letters written by the wife to her relatives showed that the husband ill-treated her and their relatives were strained, and further the evidence showed that both of them were in one room in the night. It was held that the chain of circumstances was complete, and it was the husband who committed the murder of his wife by strangulation, and accordingly this court reversed the judgment of the High Court, acquitting the accused and convicted him under Section 302 IPC. In state of TN for Tamil Nadu versus Rajendran, the wife was found dead in a hut which had caught fire. The evidence showed that the accused and his wife were seen together in the hut at about 9 a.m. and the accused came out in the morning through the roof when the hut had caught fire. His explanation was that it was a case of accidental fire which resulted in the death of his wife and a daughter. The medical evidences showed that the wife died due to asphyxia as a result of strangulation and not on accident and on account of burn injuries. It was held that there cannot be any hesitation to come to the conclusion that it was the accused husband who was the proprietor of the crime. So here in our case, Lordship, she was she was by hanging, Lordship. But Lordship, she was died, Lordship, by Lordship when there is a blow as per the postmortem report, Lordship, there is injury on her abdomen, Lordship, spleen, Lordship. So Lordship, it is Lordship when there is a no, but in 313 when he was asked whether how it occurs, Lordship, there is no any sufficient answer. Only that she is suffering from abdomen disease, but there is no any explanation, and he did not give any evidences to that effect, Lordship. And that house is he was also dwelling. Both are dwelling in that house, Lordship.
So, Mr. Gogoi, why this principle, this proposition of law laid down in this case should not be applied in your case?
Because your lordship may see the question number 31 of the 313 statement, page 34. Page 30, question number 31. PWD4 is a doctor. You also got it?
Of your paper book,
Yes, yes.
page number 30?
4.
Yes.
Period 4. Father, question 31. Period 4. Father reports that he opined that the cause of death was due to shock and hemorrhage as a result of hemorrhage inside the abdomen cavity caused due to splenic injury. What did you say? I am not aware. She was ailing for abdomen pain. He especially stated that the result that she was suffering from abdominal pain. And there is, as for postmortem, there is no accident found. And question number 49.
You are referring to question number?
31 and 49. 31 and 49. 49 is whether you have anything more to say on the case and the evidence. I was falsely implicated in the case. My wife was ailing from long and she was also treated by her parents also. I have medical documents for her treatment. This is the two expression, question number 31.
Where is the medical document?
It is not required as per Rina Hazarika's judgment. The court has to consider whether, as per paragraph number 16 and 17, the 3-1 statement has to be considered by the court.
Without any medical document, the statement of the accused has to be accepted.
As per the Rina Hazarika's judgment, the 3-1B statement has to be considered.
No,
It
has to
is-
be considered, yes, if there is any medical document to support that she was suffering from any ailment. But if there is no such a document, then
I have not said, I'm not the defense witness. Only 3-1 statement is there.
no, that's all right.
And as per Rina Hazare, your lordship,
No,
Mr.
Mr.
Rina
Gogoi,
Hazare
you
as well.
tell me, can this court accept the statement of the accused in 313 CRPC without
Yes,
there
yes.
being any supporting document
Yes,
that she was?
the court has to, the court has to consider it as per this Rina Hazare.
No, that's all right. The court has to consider it, but how?
Have to, in the,
Without there being any supporting document.
your lordship may see the judgment once again. I will read. Paragraph 16 and 17 will be clear. You have to consider under section
No,
3134.
there is no quarrel in the proposition of law laid down in the case of Rina Hazarika. But without any material,
It is a valuable right of the accused.
Uh.
As part of this judgment is a valuable right of the accused.
Mm.
It will consider as section 313
Mm.
May I read it once again?
mm,
Section 313 CRPC cannot be seen simply as a part of audio alter partum.
Mm.
It confers a valuable right upon an accused
Mm.
to establish his innocence and can well be considered beyond a statutory right as a constitutional right to a fair trial under Article 21 of the Constitution. Even it is not to be considered as a piece of evidence, not being an oath under Section 3132 CRPC. The importance of this right has been considered time and again by this court, but it yet remains to be applied in practice, as we shall see presently in the discussion to be followed. If the accused takes a defense after the prosecution evidence is closed under Section 3131B CRPC, the court is duty bound under Section 3134 CRPC to consider the same. The mere use of the word may cannot be held to confer a discretionary power on the court to consider or not to consider such defense, since it considers a valuable right of an accused for access to justice and the likelihood of the prejudice that may be caused thereby, whether the defense is acceptable or not, whether it is compatible or incompatible with the evidence available is an entirely different matter. If there has been no consideration at all of the defense, there been no consideration at all of the defense taken under 313 CRPC, in the given facts of the case, the commission may well stand visited. To our mind, a solemn duty is cast on the court in dispensation of justice to adequately consider the defense of the accused taken under 313 CRPC and to either accept or reject the same for reasons specified in writing. Unfortunately, neither trial court nor the High Court considered it necessary to take notice of much less discussed or observed with regard to the aforesaid defense by the appellant under Section 313 CRPC to either accept or reject it. The defense taken cannot be said to be irrelevant, illogical, or fanciful in the entirety of the facts and the nature of other evidence available as discussed above. The complete non-consideration thereof has clearly caused prejudice to the appellant. Unlike the prosecution, the accused is not required to establish the
that's all
defense
right.
beyond all reasonable doubt.
No,
The
Mr.
accused has
Mr.
only to raise
Gogoi.
doubts.
Mr. Gogoi, you see, without there being any medical document or any other evidence, can the statement of the accused under Section 313 be accepted?
Here,
That's why in that judgment it is stated
yes, sir.
that the explanation offered by him is acceptable or not acceptable. It is a different matter. That is stated
Yes,
in
sir.
the.
It will be considered by the trial court, but
No,
it has not been
that's
considered
why-
as per this judgment. Because it's a variable right of the
No,
accused.
even supposing the court below has not considered it, we will consider it, but where is the document to support that she was suffering from abdominal pain?
Your lordship, in fact, the independent witness, Anjan Buragoy, in his statement, he has stated that she had died, the brother said he had died of some abdominal disease.
Whose brother?
The brother of the accused. In PW2, he said. Page 27 of the paper book,
Page number?
27. Accused Suman Sharma is also known to me. This is Nirmala Thakur was also known to me. Nirmala Thakur was married to accused Suman Sharma. Accused used to live as my next door neighbor. on 21/9/15, while I went out of the home, I saw Nirmala in her residence with good health. At afternoon hours, when I returned home, I saw a huge gathering at the residence of accused. And going there, I saw that Nirmala was lying dead on her bed. Elder brother of the accused informed me that Nirmala died of her ailments. I have no knowledge about the conjugal life of the accused and the deceased.
Elder brother of the
He
accused.
is not the,
That is a hearsay statement.
But-
Whether the elder brother of the accused was examined here as witness.
but Lordship,
He was arrested, but he was not examined by the, it is a duty of the prosecution to examine.
Whose duty?
The prosecution to,
Hmm.
hmm?
That is hearsay statement.
PW
Hearsay
6,
evidence.
on the other hand, Lordship, PW6 is not the her own brother, Lordship, because his father's name is Onil Gohai Burua.
No,
Neighbor. Own brother বুলি কৈছে।
we can file petition under section 390 for giving medical evidence if required.
Pardon?
390 CRPC.
Hmm.
Arrest of accused in appeal from acquittal. Sorry, 391, appellate court may take further evidence or direct it to be taken. 391 CRPC. As per the postmortem lordship, there is no external wound. So, as per medical postmortem report, there is no external wound, your lordship. There be a chance of,
No, that's all right, but PM report also said that her spleen was ruptured.
rupture maybe as per your, on the last occasion, medical judgment, rupture maybe, I may suffer from disease from for a year.
No,
It-
that's
on
all right,
that-
but where is that evidence that she was suffering from ailment of the heart?
So there is a created doubt whether he has died of normal death or by the accused. They create a doubt. There is no proper. You can give evidence. Appellate court may take further evidence or direct it to be taken. 391 other CRPC. Whether it is a normal death or it is not sure because there is no external wound. As per the
External wound may not be there, but the own doctor has found and reported that that is the cause of her death.
it is rupture of the spleen. Rupture of maybe of anything. There is some cases on the last one I've seen. If you sneeze, if you cough, there also the spleen may be ruptured. Because if it is suffering from this disease, any disease.
But here in the medical legal Lordship, here it is the words used an enlarged spleen, it is mentioned, Lordship.
Whether she has an enlarged spleen or not,
But in a
she will
spleen,
know.
by the definition of when it is.
it creates a doubt. It creates a doubt.
But in spleen Lordship, regarding spleen Lordship,
The prosecution
normal spleen.
the prosecution has failed to prove beyond reasonable doubt. And in case and here is a small minor child, no one to look after. The fisher of the child is there. Son.
No, you show me whether this statement of the accused that she was suffering from abdominal ailment can be accepted without there being any medical evidence or not?
Yes, as per this, Rina's husband. And then there is
No. You have not understood the law laid down therein.
if there is no eyewitness, that one.
See, can this statement be accepted or not?
Lordship.
There is,
So regarding spleen lordship that I was submitting lordship. You're listening about it, huh? What you are listening? Huh? So regarding spleen lordship, here in the page 40 lordship, in the paper book lordship, her spleen is lordship in 8, serial number 8 lordship, page 40. The spleen was found to be torn and lacerated. A huge hematoma clotted blood present in the splenic area. And there is in P column P lordship, injury, a liner mark in the front of neck lordship. Injury is also there lordship. And spleen is
Where?
page 40 lordship. Paper
Yes.
40. Spleen is in serial number 8.
Yes, got it.
Here it is not, let's say it is a annular spleen or something like that lordship. It is a spleen is like simple spleen meaning lordship. And in this meaning of spleen lordship, if you go by medical legal lordship, here it is said as on account of in situation, rupture of a normal spleen is very rare unless caused by considerable crushing and grinding force, such as the passing of a carriage or motor car over the body, or by a crush in a railway accident, or by a fall down a very great height. In such cases, it is usually associated with injuries to other solid organs and to the ribs overlying the spleen. So lordship, it cannot, in normal sense, lordship, it cannot be lordship. That in normal sense, it cannot be lordship. The rupture cannot be done lordship in such a in like that lordship.
no, last occasion,
Spleen lordship.
I have read the whole thing. about
Okay,
the
মই পিছত
spleen.
মানে কেনে মই কৈছো normal আৰু হেৰি কথা হৈছে enlarged rupture enlarged spleen and normal spleen. Here it is not written is not mentioned, it is a enlarged spleen lordship, it is a normal spleen lordship. If it was enlarged spleen, then it would be written as enlarged spleen lordship. And thereafter lordship, if your lordship kindly go through the judgments lordship of lordship Trimukh Maruti lordship, here para 13 lordship. And para 13 last part lordship, last line lordship.
Which one?
There should be, lordship, there should be specific,
Let him complete.
Para 13 last line lordship.
Para 13 of?
That's been Trimukh Maruti lordship.
Yes. 13.
13. আপনার নাম নিগলি বলবো, আপনার মুসলিম বলবো 13.
Yes.
The last line lordship.
Hmm.
13 last line.
Hmm.
The parents or other family members of the bride being away from the scene of commission of crime are not in a position to give direct evidence which may inculpate the real accused except regarding the demand of dowry or dowry and harassment caused to the bride. But it does not mean that a crime committed in secrecy or inside the house should go unpunished. Thereafter 14. If an offense takes place inside the privacy of a house and in such a circumstance where the assailants have all the opportunities to plan and commit the offense at the time and the circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstance evidence, as noticed above, is insisted upon by the courts. A judge does not preside over a criminal trial merely to see that no innocent man is punished. A judge also presides to see that a guilty man does not escape both the principal duties, both are public duties. Therefore, said the law does not enjoys a duty on the prosecution to lead evidence of such character which is almost impossible to be laid or at any rate extremely difficult to be laid. The duty on the prosecution is to lead such evidence which is capable of leading having regard to the facts and circumstances of the case. Here it is necessary to keep in mind section 106 of Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. So, Lordship, here the knowledge, the special knowledge is that Lordship, she is some from abdomen disease, Lordship, and so the burden of proof is upon him to prove that that burden is how whether she is really she is suffering from that disease or not, Lordship. But he did not introduce any evidence in his.
Where is Mr. Kyle?
Lordship, he has left the court, Lordship.
But can you appear on his behalf? You can take adjournment or other, you can mention that is a different aspect, but can you argue the matter?
Lordship, I
So
know
they
the
were
date.
not the panel lawyer,
Yes, Lordship.
then
Lordship,
in case of mentioning, we accommodate you, but we cannot hear you
Lordship.
because you are not authorized here. If somebody put question, how can court hear you? Then we have no answer.
Lordship.
So you tell Mr. Kyle that this practice should be avoided. Yes, Mr. Ahmed,
Lordship,
your
Probably-
contention was on the ground of delay
Lordship,
because till that no charge has been framed against her.
Lordship.
So, in view of this judgment,
Lordship.
can this alone be the ground?
Lordship, that I will address. Probably your Lordship has correctly pointed out that her senior's presence will be probably required. So I have got one citation where direction was there from the High Court. Trial was to conclude within 1 year. That was not concluded. Thereafter, Supreme Court considered and held that substantial compliance of Section 37 is there.
Who is judgment?
Just I'm placing that. And regarding Article 21, it is absolute, it is not absolute, right? That also I have to submit. It is, I will accept that part. Paragraph 4, Lordship, may I see? The investigation is complete. Charge sheet has been filed, though the charges are yet to be framed. The conclusion of the trial thus will take some reasonable time regardless of the direction issued by the High Court to conclude the same within 1 year from the date of framing of charge. The petitioners do not have any criminal antecedents. There is the substantial compliance of Section 37 of the NDPS Act.
Okay, you furnish a copy to her. Let Mr. Kyle explain it on next day. Sorted. Can it be on Monday?
Lordship.
Actually, on 5th.
5th.
Can it be on Monday, Lordship?
Monday.
Monday, how many matters are there? So, Mr. Ahmed, on Monday, lot of cases have been fixed, already fixed. And this court is also sitting in division bench. So after raising the division bench, this court can sit here.
Lordship.
So on that ground, it may not be proper to fix on Monday. Because today also some matters have been mentioned.
Lordship,
On 7th.
7, my senior will be out of station on 7.
Not 7,
On 5th.
5th of June
Okay, Lordship.
or 4th of June. Tuesday. Okay, Tuesday then. Tuesday. Heard Mr. A. M. Ahmed, learned, no, A. Ahmed, learned counsel, accused. And Ms. Deka appeared on behalf of Mr. S.C. Kyle, learned standing counsel for the NCB. This is a list the matter on Tuesday as per that. You furnish a copy to her.
Deeply obliged.
Any other? What do you that are ready to? Either. No, no. Itu belajar kan? Six months, half an hour. No, ya está,